Good afternoon, everyone. Allison Schaberg here with Consolidated Planning Group. We are happy to be here and be invited by Liberty ISD today. If you are joining us for the first time, we're really glad you're here. If you have attended some of our webinars in the past, we're glad you're back. So for a little housekeeping for today, this webinar is going to go from 12 to 1. We will be finished by 1. So if you're planning or you're at work and you got to get back, just know that. Your cameras and your microphones are muted, so we can't see you and we can't hear you. But your questions are very important to us today. So as we're going through this presentation, if you have questions, we do want you to put your questions in the chat box. I'm going to be monitoring the chat box today for Boyd, and I'll be asking him the questions, and we're going to get to just as many questions as we can. Today's webinar is being recorded, and either later today or tomorrow, you will get an email with contact information for myself with Consolidated Planning Group and Boyd Handley with the Handley Law Office. So Consolidated Planning Group, we are a holistic special needs financial planning firm. You may have seen us before. We do a lot of webinars as it relates to planning, transition planning, any number of topics, which we'll have kind of some things that maybe should be on your radar at the end of this webinar that we'll hit on. We also have a YouTube channel. So if you've missed some of these webinars and some of these topics that you see at the end may be relevant to you and kind of the path that you're on with your loved one, you can certainly circle back to those on our YouTube channel by subscribing, and then you can listen to them at your leisure. So having said that, I am back together here with Boyd Handley, the Handley Law Office, and I always enjoy doing these webinars with Boyd. Boyd is a wealth of information, and today's topic is the ever popular topic of guardianship, which is one big thing on that transition checklist that we all hear over and over. So you're going to be delighted to hear all the things that you need to know about the ins and outs, and should or shouldn't you go down the path of guardianship. And I hope that this will be valuable information to you today. These are just some things. I'm not going to belabor this. I'm just going to move forward right on over to Boyd. Boyd, I'm going to hand it over to you.
Okay, thanks, Allison. Thank you, everyone, for being here. Just to give you a little bit about my background, I've got a daughter with special needs who's 27. We have guardianship of her, so I've been in the same situation a lot of you may be in at the present time. Unfortunately, I have to give you this disclaimer. This presentation does not create an attorney-client relationship. And also, I want to mention that each person's situation is unique. So this is just general information, and it may or may not apply to you in most cases, and it's really on a person-by-person basis. Next slide. What we're going to talk about today is the left-hand portion of what I call the Special Needs Toolkit. You really need to have all these things in your toolkit when you're dealing with a child with a disability or special needs. And today we're going to talk about guardianship and the alternatives to guardianship and which one works for you. Next slide. As I mentioned, we're going to talk about the middle portion of all of this, guardianships and alternatives. There's other, as mentioned in the previous slide, there's other things that you need to think about and go forward with as you go forward with your loved one. Next slide. Why do we need guardianship in the state of Texas? Unfortunately, when our child turns 18, everything we were doing a day before that goes away, and we either have to have an alternative to guardianship, such as maybe a power of attorney, a medical power of attorney, or need to get guardianship off our loved one. Some of the things that we'll be talking about, of course, guardianship, of course, decision-making agreement and how that differs from a power of attorney and medical power of attorney, and also the HIPAA agreement. Next slide. When someone comes into my office, I use this is from the American Bar Association, but it really helps me to decide on whether the individual needs a guardianship or not. And I won't go through all of this, but basically I look at each one of these issues. First, I presume they do not need guardianship. And then I start asking the family what's going on, identify the abilities and the challenges of the loved one to see whether we need to go forward with a guardianship or use some alternatives to guardianship. Next slide. Major changes happened in Texas in 2015. We had some major reforms. We had a bill 39 that talked about the alternatives to guardianship, and also passed another bill on decision-making agreements. Basically, what this did is that as attorneys, and of course we always did this, but now we were required by law to look at the alternatives to guardianship to see if a full or partial guardianship is needed on your loved one. This really comes into effect if the person has already reached the age of 18, but we always do this anyway. We'll go into more detail on the supported decision-making agreement, which was also passed in 2015, which is really a go-between between guardianship and the alternatives to guardianship. And we'll discuss that later. But major things happened in 2015 in Texas. Next slide. Guardianship can be full or partial. In most cases, when our kids are turning 18, we have guardianship of the person. There's also guardianship of the estate. That's really mostly used with elderly people who may have homes or bank accounts and things of that nature. And then in those situations, we probably will have a guardianship of the person or estate. There's also temporary guardianships that may come about if the guardian of your child may live overseas and a parent dies. And then what we would do there is set up a temporary guardianship until that person comes into the United States from overseas and files for guardianship of the child or loved one. Next slide. Full versus partial. Also want to say that guardianship is not permanent. A number of years ago, I was sitting in on the new dockets for the judges that were sworn in 2019. And I had a young person sitting next to me. He was nonverbal. He was talking to me in his little electronic contraption. And we were talking and had a very interesting conversation. And then lo and behold, when we went into the courtroom, he was getting his guardianship given back to him. He had gone to HCC in town. They have a great program for children with disabilities or young adults with disabilities. And he had gotten his computer science degree and was getting his full guardianship returned back to him. I have to say there was no, every eye in the room was teary-eyed, and it was very nice to see that. I tell parents all the time that it's not permanent, but it was nice to actually be part of one of those procedures. When you talk about, we'll go ahead, next slide. Guardianship can be full or partial. I've got the couple of the major rights that are taken away at the beginning, and then we have the remaining rights that are taken away in a full guardianship. And you can kind of pick and choose depending on the how your loved one is functioning in life. I will say that we're going to go over something called the physician certificate later, but in the physician certificate, it goes over how the disability affects the everyday life of your loved one. And in a lot of those situations, you have the check marks on a lot of these rights. And so when you do talk to your physician, be sure that the rights that you want to keep are not checked off on that. In most cases, we can ask the judge to, even though they're ticked off by the physician, most of them cannot be changed, but I have had in the past the ability to change the right to vote. Next slide. Guardianship of the person, as I mentioned, most of the time when our kids turn 18, that's what we apply for. I've got that on my daughter, who's now 27. And it basically, we go to court and basically take care of those rights that you have previously looked at. And really, basically, guardianship of the person is doing everything you did for your loved one prior to the age of 18. And really nothing changes except you have the legal authority to make decisions for your loved one. In this situation, the only thing that you really have to do each year is to provide an annual report to the court, and then renew your guardianship letters each year. Next slide. Guardianship of the state. In most cases, if your loved one's turning 18, this is not used. I've had a few of these with adults that have been in catastrophic accidents in their midlife, and then most of the times these are with elderly people. The main difference is that you'll have to do a financial bond on the value of the estate of the person you're getting guardianship of. We have to file a physical inventory, and then this has to be done each year. So it's a lot of paperwork and involvement. The court is involved in it. You must go back to the court each year and tell the court how much you've spent and what you've spent the estate on. So very complicated, but in most cases, with our kids turning 18, we won't be using this.
So for this one, Boyd, in this example, where this would be necessary is if, maybe your child's disability was because of a, medical malpractice or some kind of accident, and there was a lawsuit and there was a settlement. This would be an example of why you might have guardianship of this estate, but your child having a checking account that has less than $2,000 in it is not an example. Is that correct?
Yeah, that's correct. In our situation with my daughter, of course, she gets SSI and Medicaid. We have a rep pay account that my wife is the rep payee for my daughter, and we have a checking account for that rep pay account. In regard to a loved one getting such as a court settlement, what we do with that is that we move that settlement into a first party special needs trust, and then that is not counted against Medicaid. And that's if we normally do that prior to the end of the court hearing. If something's done and that's not done, we can have a trust set up in the court and go from there. But in most cases, the attorneys will be calling someone like myself, and we'll set up that first party trust for that court settlement.
And Boyd, I'd like to, before we move on, I know we're going to move in to the other, forms of guardianship, but we were talking about full guardianship. And so for those families, we work with families all the time. And for some families, it is crystal clear that they need guardianship. Okay, their child is nonverbal, they have intellectual disabilities, whatever. And in some other families, so could you tell everyone today, like, what is clear, in that scale of intellectual disability, or what are some clear signs that full guardianship may be necessary?
Sure. It really has to do with the physician certificate. We will go over that here shortly, and how many boxes are ticked off as far as how the disability affects the everyday life. And in reality, it's very obvious when you do that. And it's also obvious if they have a low IQ. If they got a low IQ, then they really cannot do a lot of the things in everyday life. Now, from a partial guardianship standpoint, I've had very high functioning kids. I've had one with IQ of 125 go through guardianship. He had some mental issues. And so, you can be high functioning from a IQ type situation, but have a lot of mental issues that guardianship is needed. I've also had children young adults that had a driver's license, and we have guardianship. I'm not sure I would let my child drive if I had a guardianship, but could be some liability there. But so it really, you have to look at everything as far as guardianship. But the main deal is that if you have a very low IQ, then first, you cannot sign a power of attorney, a medical power of attorney. So guardianship is your only alternative. You're muted, Alice.
Yeah. So one more thing. So we know that from a transition perspective, and I think that's one thing that you mentioned, that you can start the guardianship process 180 days. That's what it says on here. So 6 months prior to the child turning 18.
Yep.
So what if I'm a parent that has a child that's over 18? I didn't know what I didn't know, and I didn't go through this process. Is it too late?
No.
Can you talk to those families as well?
Yeah, no problem at all. Probably about half of mine clients have already reached the age of 18. The only difference is that the court will really look at the alternatives to guardianship. And there are a few judges that we have to go into more detail about that. So that's really the only difference. I'm doing one now where the child's 50 years old. Well, the adult's 50 years old. We're going through guardianship. You know, it's really very rare that you get an older person that's not elderly that you're going through guardianship, because in a lot of cases, the hospital has already said that they're not going to talk to you unless you have a medical power of attorney. And so I had a client that called me the other day, and they have reached the age of 18, and unfortunately our hearing is not for another 10 days, and one of the hospitals in town have already cut them off the account. So, you know, the hospitals are very proactive about when these kids turn 18, they look at their records and really start cutting mom and dad off. So if you're lucky enough to have a child that's past the age of 18 and you haven't run into those issues, then good for you. But at some point, they'll probably catch up with you.
And for some, their kids will still, for many, their kids will still be in high school post age 18. So this is where this conversation may, you know, really be necessary. And there's some other options as well. But for those that are still going to be in school and you want, you know, you need to be involved in that educational process, that might matter as well, right?
Right. Interesting enough, a lot of the schools will have you sign a power of attorney or have the child sign a power of attorney, and in reality, they probably do not have the capacity to do it, but you see that happening quite often. As we mentioned before, you can file 180 days before the 18th birthday. I normally tell parents to give me a call 8 months ahead of time. They have to have a physician certificate filled out, and with the COVID and stuff, it may take excuse me, longer to get an appointment. And also the physician certificate has to be evaluated and signed within 100 days of the filing date. So I've had some parents in the past that the doctor saw them 6 months ago and they signed it, but we have to have everything within 120 days of filing. Some of the things that may shock you, once we file for guardianship, the court will have a constable serve your loved one with a citation. In most cases, that's very frightening. I know with my daughter, she loved it. The sheriff was at the front door. So, but a lot of parents, that could be shocking to them. We also, guardianship steps, we'll go over this shortly. We have, they have to have a 30-minute PowerPoint presentation and get a certificate. In Harris and Montgomery counties, those are statutory probate courts, and they will appoint a court investigator to come out and visit with you and your loved ones. That's currently being done by Zoom. And then once that happens, then you'll have an attorney ad litem appointed by the court to represent your loved one in court. If your loved one has any elder siblings, we'll be getting a waiver from them saying they agree to mom and dad or one of the parents being a guardian. And if you're in a divorce situation or one of the parents is not going to be the guardian, then the other parent has to sign a waiver to do that. Next slide. Here's just the training course that's now, I think it's been 2 years. It's now required for all guardians. I was grandfathered, but I actually took the course. When I was taking it, you had to answer questions, but I think they've changed that where you don't have to answer questions, just have to go through the whole thing. But it's very interesting, very informative. And I'm really glad that that's required for the guardianships. When you do go through a guardianship, I'll go in and register you with the judicial branch in Austin, give you a password, and then all you have to do is hit on the links and take this course. Once you take the course, you'll be given a certificate, and we have to file that certificate with the court to go forward with the guardianship proceedings. Next slide. Next slide, Allison. Sorry.
We actually had a question on for this physician certificate, so it's really timely. Should the physician themselves have this, or should they take this paperwork with them? Is that best? Is it online, or how do they get a copy of this?
Yeah, what I do with my clients, I send them, when I send them the questionnaire, I also send them the physician certificate, and they can either hand carry that to the doctor, or, fax it or email it to them. I purposely made this where you can't read it, but this is the first 2 pages of the certificate. And all the boxes that you see is how the disability affects your loved one in their everyday life. And there's a lot of yeses and nos on it. And basically the physician ticks those off. And this helps the court understand your loved one's disability and whether guardianship is needed. I will say on the first page, there is a Miranda right type deal, which basically you have to inform the loved one that the communication with him or her is not confidential. And that's one thing I tell the parents: be sure their physician marks that as being told. There are some courts that will allow that to be hit no, that the person was not noticed or given that information. And that will depend on the attorney ad litem, whether he or she will agree to go forward with the guardianships. And there's some courts in the counties that if you don't have that check, then they won't go forward. So in some situations, we've had to go back and have a new physician certificate amended, and for that to be done. Next slide. Also want to say on that physician certificate on page 3, there is a box for intellectual disability. And in a lot of cases, the intellectual disability test has been either done by your school or it's been done by a psychiatrist. And your personal physician may not have done that. So there is some boxes. If you want to use that particular report, the physician can check off that he or she is used another report, and then use that report to check off the boxes on the IQ number. And I will say that as long as the IQ test has been within the last 2 years, it can be used in the report. Most people can qualify for guardians. The ward's parents can be the guardian. If you're divorced and have a step parent, he or she can be a co-guardian as long as the biological parent signs off on that. I've done a number of those. In most cases, it's hard because the biological parent does not want a step parent being guardian of their child with that. One thing that will keep you from being qualified of a guardian is have a felony offense on your record. I have had one case where a parent had a felony drug conviction 20 years ago. And we were able to get letters of reference and show the judge, and the judge allowed that parent to become a guardian. DWI. If you've had a DWI, I've only had one of these cases, DWI in the last 2 years, you can't become guardian. That's been with one judge, so I don't know how the other judges agree with that, but unfortunately, the parent did not tell us until the hearing, and at that point, the judge said, come back in 2 years. If you haven't had a DWI, then we will look and take in consideration whether you can be a guardian. I will say that in all the surrounding counties, I do Waller, Montgomery, Fort Bend, Harris counties, the judges are fantastic. They really look after the child's interest, very understanding to us as parents becoming guardian. They understand what we go through. So I've been very pleased with that. Won't go through a lot of these, but they will ask you if you owe the guardian the ward. Unfortunately, that's the terrible name that they name our loved ones. If you owe the ward any money, then you can't be a guardian. So between the criminal history and the owing of money, those are the two main things that will get you disqualified to be a guardian.
We have one question, and then I want to bring something up that usually comes up almost every single time. What if we have an oppositional parent, divorcee, or whatever parent that doesn't, nobody even knows where they are, they don't pay, they're not involved in the child's life, or B, they're just not for this and don't want to sign off on this. And then the last part is, what if we have a parent, a biological parent, and again, this doesn't matter in adoption. So if you've adopted the child, you're their parents. It doesn't matter about bio, but typically the bio parent, if someone is out of the country or something like that. So can you talk about those three scenarios that almost every webinar comes up?
Yeah, sure. You can be a guardian if you're out of the country to a certain degree. You probably will have to either take the child back where you are, but that guardian who's out of the state, out of the country, or even state, will have to come into Texas and go through the guardianship proceedings. I talked about temporary guardianship before. A lot of those situations where guardian lives overseas, the parents have died, and then we would do a temporary guardianship with a friend in the state in order for that guardian to get a visa or wherever to come into the state. But he or she would have to go through a full guardianship proceedings. And then, of course, the judge will, and even if it's out of state, the judge will look at what's going on to see if that particular person is the best one to be guardian. What was your other two questions?
So I think, so basically in Texas, so if we have a parent that is against like a divorcee, so the courts follow the best interest of the child. So even if you have somebody that's like adamantly against guardianship, if the courts rule it's the best interest of the child, does it matter that you have a parent that's so against it?
No, not really. What would happen if we know, just say you've got a divorce or you've got a biological parent who is not married before, if we know their last known address, we would send a waiver to them by certified mail. It can either be deposited with them and their signature saying they received that, or their letter can come back undeliverable. And then we file that with the court, and that's all that has to happen. The biological parent that's trying to get guardianship will go through the court and get it. If you've got a divorce situation, the same thing happens. We have to serve the other biological parent with a waiver. And if they contest the guardianship, then in most situations they would hire an attorney, and then we would go to a contested guardianship. At that point, in most cases, it's you go to mediation or even prior to mediation and explain that to the biological parent that is contesting it, that the ward has rights. And these parents have to realize is once they turn 18, all the things that they've talked about in the divorce decree, such as dad or mom getting the child on every other weekend or on Wednesdays, really goes away. And the parent that's getting guardianship has the rights to make a lot of decisions for the loved ones, but the loved one has rights too. We normally give this out when we do the guardianship, or we always do. So when a child becomes under guardianship, he or she still has the ability to say, I don't want to go visit the other parent. And that's the hard part, because they're adults and they have a right to pick and choose who they go see. And so that's one of the most problems, is that I've got parents that call me up and say, do I have to take my child to see the other biological parent? If the child does not want to, you do not. And so that's probably the main issue that I see, is that these kids have rights even though they're under guardianship. And even guardianship is once you have that, the child has a right to go see people. The child has a right to have visitors, as long as he or she is not in immediate danger. So, unfortunately, they can even run off with someone. But if they're not in danger, you can't call the police up and go get your child. So there's a lot of nuances that even go along with having guardianship of someone. I know someone's asked me in previous seminars, is that, do we have liability for our child or young adult that we have guardianship of? Yes and no. They can still commit a crime. You're not liable for them committing that crime. And I'm not a criminal lawyer, but in most cases, if they don't have the capacity to understand, then there probably won't be a lot of criminal activity against them. Now, the only way that you could be liable, and then this is just in general, is that, again, you've got guardianship of someone that's been declared to have incapacitated, and they still may have a driver's license and could be driving. So you need to be very careful if your loved one is driving a car, that they have the ability to make split decisions on driving and looking after everything else. The other situation that may come up is that if your loved one maybe had a sealed juvie record and may have done something in the past that could hurt someone in the future. And I've had one situation like this, and I basically told the parents is that if this loved one is in a group home or goes to a day program, you need to tell them in confidence what that juvie issue was, because if that juvie issue comes about again and you don't inform someone of that possibility, you could be held liable for that.
Okay, we have a quick question. You said ID testing needs to be done within 2 years of the request for guardianship.
Yes.
Should school districts be prepared to reevaluate students closer to their 18th birthday?
A lot of times they don't. You just have to have that in your IEP and ask them to do it. They probably will. Some situations they don't. And then, unless in a lot of situations, you may not need that in your physician certificate. So if you're on the borderline, it might be needed. But if you're not, and you have a number of other boxes checked off for other very problems or disabilities, then that may not even be needed.
And one other thing, because I do know that sometimes that testing in the school district can be difficult. I mean, there's only so many testers, and they only have so many slots and those types of things, and it needs to be scheduled in advance. But one other thing that I wanted to mention is your local intellectual disability authorities. Some people refer to it as a LIDA, some people call it a LIDA, your local intellectual disability authority. Like, for instance, Harris County is the Harris Center. It used to be called MHMRA. Every county has one. They also do this type of testing. It's free of charge, and they will determine your child's level of need of care for the future. And they can do some of these testings, this IQ testing and that kind of thing. And it's typically free. So you may want to check with your local authority as well. If maybe you've just had your ARD meeting, you've just done what you were going to do, or maybe it's you're not going to be able to have it in time or whatever. That's just another way. And one other place that you may consider as well is if your child is signed up with the Texas Workforce Commission through vocational rehab, they determine what assessments they're going to do for your child based off of what is needed. But very commonly, they do a neuropsych test, which will have the IQ included, and they will also do a vocational evaluation. And that would be part of the VR program. So there are some different areas and avenues where you can get this testing done outside of the school district if they're booked up or what's going on.
Yeah, good point. I will mention that those institutions are usually backed up right now. So I would definitely contact them if you need to get an IQ testing done at least a year ahead of time. And also, you've got a lot of psychologists and psychiatrists in town that also do that. What we're going to do now is skip to the alternatives to guardianship and go over what the durable power of attorney is, the medical power of attorney, talk about supported decision-making agreements. Those are great, but they have their limitations. So we'll go forward with that. Next slide. The main thing I tell parents is that the power of attorney and medical power of attorney, the young person has to have the capacity to understand the legal ramifications of it and what they're actually signing away on. I've done a few of these for kids turning 18 with disabilities, but what I do in my practice is I have the young person come into my office, mom and dad are sitting out in the waiting room or in the conference room, and I ask them questions. And because what happens if these young people are in the same room with mom and dad, they look to the left or look to the right and see if mom's going to or dad will shake their head, yes, that's the correct answer. So I'm very particular when I do these. I actually have a IQ cutoff in my practice that I use just because I've got a daughter and I understand the issues with understanding these documents. But these are great if your child has the capacity to sign them. And if you go in and have them sign this, then they don't have the capacity and something happens and someone calls you with that, there could be some liability issues with you. Next slide. Supported decision-making agreement. As I mentioned in 2015, this was passed by the court, and it's a document that is gray in the area on the capacity to understand what your loved one is signing. And with that in mind, it's really a go-between if in some situations you don't want to get guardianship, or at this point you can't afford guardianship, and you definitely know that they don't have the capacity to sign a medical power of attorney. Next slide.
Boyd, I just wanted to mention on the last slide on the power of attorney and healthcare power of attorney, I always try to say this every single time we talk about this because it is super important. If you have other children that do not have disabilities, that have turned 18, they're going off to college, it's real important to go ahead and have that healthcare power of attorney on those kids, because if they get in an accident, something happens, not having that is a bad thing. And maybe you have a power of attorney that you become the power of attorney in the event that they're incapacitated. So that's another thing. And then on that same note, if you're at an age where you're having transitioning kids, you may be at an age where you have some aging parents, or they're heading in that direction. Yep. Anyway, so I would just, my recommendation is, as you're thinking and planning for your own family, have these meaningful conversations with your aging parents about their power of attorney and their healthcare power of attorney. Don't wait till somebody has COVID, has had a stroke, or a heart attack, or has become incapacitated acutely to find out that there isn't anything like that in place. So I always like to mention that. Let me just check the chat box really quick. It looks like we have a question. And someone says, it's a question. We can get a healthcare power of attorney with a child with IDD. And that's basically what you were saying, is if their IQ is basically 70 or below, as an attorney, you're not going to do that because that child doesn't have the capacity to understand what they're signing. Is that right?
Yeah, in my practice, I have a 70 cutoff. I know there's some attorneys in the area that probably go to 65, but I cut mine off at 70. I'm glad you mentioned that about kids going off to college, or elderly people. What we see a lot, I've done quite a few lately with kids going off to college. The problem with elderly people or your parents is that they have each other as the power of attorney, and you get one with dementia, and then both of them may get incapacitated. Then the only thing you can do is get guardianship of them. So it's very important for them to have one of their children or friends on the power of attorney. In most situations, I was very lucky with my parents. Before they passed, I was on their checking account and power of attorney. But you have some parents that do not want their kids in their business. So we can actually put in the power of attorney that a doctor has to declare your parent incapacitated, or even two doctors. So when you're talking to your parents and trying to get those agreements signed, tell them that we have to go through all of this just to do that. One other situation I've always liked to mention, I've had a number of parents that have adopted kids from overseas, and they have what we call fetal alcohol syndrome. That's where the mom was drinking during gestation, and as they grew older, they actually, a part of their brain is missing. These kids can be very high functioning, but they have a very high tendency with anger issues. And the issue with the power of attorney and medical power of attorney, if your loved one wakes up one morning and they're mad at mom and dad for not letting them look at TV or something, and they tell it to the correct people, your power of attorney and medical power of attorney goes away. And so with these kids with that particular situation, or maybe others that are high functioning with mental issues, you really need to look at either partial guardianship or understand the limitations of a medical power of attorney or power of attorney if your child has a tendency to have anger issues with you. Next slide. I think we've touched on a lot of this. With decision-making agreements, there is a gray area with the capacity. So you can theoretically have a low-functioning person that can sign one of these and get by with it, but just be careful with it. Next slide. This is extremely important because the title of this document, Supported Decision-Making Agreements, you may think that the parent, once he or she has this, can make decisions for their loved one. That is not the case. What this agreement will allow you to do once your child turns 18 is to go to meetings with them and assist them in explaining what the meeting is about, where your loved one can make that decision. You cannot make a decision for your loved one. So I really counsel families that are going this route to understand what you can and cannot do. And this can actually be done with a power of attorney, medical power of attorney also. But you just need to understand this is really a go-between or in some cases, a Band-Aid in order for you to eventually get guardianship, but it will help you go forward between now and a guardianship. This may actually work when a parent is getting guardianship. Their child has already turned 18 and we haven't had the hearing. So you can possibly use this in order to get into meetings with your child until you have the hearing, because they're not going to question the capacity of your child for this. But again, I would be careful with that. Next slide.
And again, this document does nothing for like the healthcare power of attorney, like we were just talking about. So it's important to understand that if you have this alone and you don't have a healthcare power of attorney, you got nothing when it comes to some kind of major, hospital event or medical event or something like that.
Yeah, that's for sure. I've had a friend of the families that they have a fairly high functioning child that's had turned 18, and she ran away from home one time and was taken up in one of the psychiatric facilities here in town. And mom and dad didn't have a power of attorney or a medical power of attorney on the young lady, and it took them 2 weeks to find out where she was. So you really need to make a decision on either getting those two documents or getting partial guardianship of your high functioning child, because you can really get into trouble with that. Again, as we mentioned before, once our children turn 18, they're adults in the state of Texas. You have no right whatsoever to make any decisions on their lives unless you have a power of attorney, medical power of attorney. And what I tell parents is that when our loved ones sign these, we normally have it being effective once they sign it, because at that point, you really, even with our kids going on to college, you really need to be able to make a decision very quickly for them. And we normally talk to these young kids going to college and or young adults and say that mom and dad is not going to make a decision for you, but we need this in an emergency. And they usually agree with that. Allison mentioned about your parents, very important. As I mentioned, be sure to have those documents on them naming you as a secondary agent for your parents. And because there's no reason for you to have to file guardianship on your parents if you don't have those documents in plan.
Boyd, this slide right here where you're getting ready to talk about the partial guardianship, I really love this because a lot of people don't know that there's really an option for partial guardianship as opposed to full guardianship. And we work with a lot of families. Their kids may be ADHD, they may be high functioning or moderate functioning, autism, they may have a disability where their maturity level is a few years behind their peers. So it is expected that they will get there, but they're not quite there yet at 18. So talk to them about how partial guardianship may be a fit in situations like that or with mental illness.
Absolutely. You can get partial guardianships. Well, let's back up a little bit. Once they turn 18, it's like someone taking advantage of an elderly person. Someone can come into your loved one, have them sign a legal document, and it'll be legal. Unless you have a partial guardianship, maybe taking away the rights to sign financial documents or contracts, because they're not mature enough to make those decisions. And I tell parents is okay, that's great. When these kids turn 18, they may not be ready for the real world. And what we're trying to do, even though guardianship is very emotional, I'll go back to that story. Right now, we're doing guardianships by Zoom, so it's not quite as emotional, even though when you're taking away rights of your child, that's a very hard decision. But what we're trying to do is protect them from the outside world. I knew my wife and I knew our daughter was going to have guardianship when she turned 18, but it was still like someone hit us in the face with a bat. Very emotional. Of course, when we were doing it, we still had to go to court, stand in front of a judge And in our situation, the judge was asking my daughter some questions, and she had this bewildered look on her face as, why are you here? And then as she progressed with harder questions, she understood why we were there. But, it's very emotional. And even though you have guardianship of your child, if they mature in 3 or 4 years or 5 years, or learn to deal with their disability, we can always go back to probate court. That's where guardianships are held, and give either all of their rights back to them or give a few back to them. So, it's not a doer, it's not one of these things that's it's done once you do it. Very open, and it really looks after how to protect your child when you need to. And if they grow up where you don't have to, then we can give them the rights back. One thing I didn't mention, and I do normally do this when we do the wills and stuff, but how you handle the guardianship of your child, if you and your spouse, if you have co-guardianship, die in an accident, we have a form that can attach to your will or put in your will who your alternative guardian will be. And that's very crucial to have. And normally how that works is that person that has been named as your alternative guardian will take the death certificates, and then we'd go through the probate proceedings as we did with you. And it's very important to have a will if you have a child that you have guardianship, because if you die intestate in Texas, which means dying without a will, Texas will tell you who should be the next guardian of your child. They go with the grandparents first, brothers and sisters, and then aunts and uncles. So you may have great parents, but some of those may not be the right person to be guardian of your child.
So in an example of a partial guardianship, is it true that you could take some of the rights away? Like maybe they still have the right to vote, they still have the right to drive, but maybe they don't make good financial decisions, and maybe they still need help with their medical decisions.
Yep.
So there's a little bit more of a picking and choosing that can happen with a partial guardianship than a full guardianship. Is that correct?
That's correct. In the couple of slides back where I had the list of all the rights, you can basically go in there and pick and choose which one. What you have to be careful is be sure that when you have the physician certificate filled out, that you talk with the doctor, and for both of you to agree with what rights can be retained by your loved one and what rights are taken away. I will say that we've had one before where as we got in the hearing, one of the moms, we had full guardianship, and one of the moms wanted the daughter to vote. We were able to talk with the judge and explain why we thought the child should be able to vote, and was able to get by with that. But that's really the only one, other than one other general one where you can argue with the judge and they will allow it. So that's one thing that you need to be careful about.
I've also seen some parents use the ability to drive, even on the partial, to take that away because their child really wants to drive, but the parents know in their heart of hearts it's not safe. And so instead of being the bad guy saying you can't, then basically it's just part of this guardianship deal that you can't. So it's kind of like taking this, the emotion out of it. Maybe, maybe they can earn that back. So I've actually seen some families do that as well, hoping that their child would get there to to a place where they could be a safe driver, but maybe not yet.
Yeah, once you take that away, it's the voting, the driving, and the ability to purchase a firearm. Those three ones actually go out to the county establishments that handle that, or the state establishments that handle that. So that's those three you cannot do anymore, and you would have to go back to court to have those given back. And a lot of these rights that are taken away, as the child's guardian, you can let them do that as long as they're not out in public or may harm someone. Main thing about guardianship is just giving you the ability legally to look after your loved one. But the main ones, driving, voting, and purchasing firearms, once those are taken away, then they're done until you go back to court.
So we had another question that said, how is full or partial guardianship as it relates to a child that might be working with TWC and VR?
No effect whatsoever. So.
Right. Right. Well, Boyd, thank you. This was really valuable information again today. Thank you for joining us again. Up on the screen, we just have some bullet points of some things that, may really should be on your radar as it relates to special needs planning, transition, money in the right buckets, so we preserve eligibility for SSI and Medicaid. We have webinars on all of these topics. We have upcoming webinars. We do several a month, usually a couple, 2 or 3 each week. So if you, have the ability to join us, they're always from 12 to 1. But you can also check out our YouTube channel and subscribe to that, and you can see, because there's definitely recordings on all of these past webinars. And our Facebook page typically has upcoming events as well. Let me see if we have one more question, Boyd. Okay, lots of thank yous, because you're awesome, Boyd. You did such a great job. You always do. And here, you guys can take a screenshot of this if you want. But again, if we are going to send an email with this recording and our contact information. If you want to reach out to Boyd on your unique needs as it relates to your options for guardianship or the other things that he mentioned, certainly reach out to him directly. We'll have that in the email. And when it comes to the special needs planning side of the house, a lot of people are confused when it comes to a special needs planner and basically an estate planning attorney or a special needs attorney. What is the difference? Don't we do the same thing? And it's true that Boyd's very knowledgeable about the things that we do, and that I'm very knowledgeable about the things that he does. But when it comes to an attorney, there's a legal documents, the special needs trust, the guardianship, all of these things, healthcare power of attorney, these things. There are these legal conversations in the legal documents, and I'm the money. I'm the funding. I'm the determining what the future care costs for your special needs child are going to be, and if the assets that you have are going to be adequate to provide for your own retirement for 25 to 35 years and then fund your child's care. I'm the funding of the special needs trust and these types of things. So, and also, we also do a comprehensive Social Security analysis that will help you identify when and what is best to file, considering you have a disabled adult child on your record. So we're able to help with all of those things. We just like to kind of differentiate and kind of show the differences, because if you had confusion on that, you are certainly not alone. Well, thanks so much, everyone. I got 2 minutes to 1, so we're finishing a little bit early. We're glad you joined us today, and we hope you'll join us again. Thanks again, Liberty ISD, and we look forward to being back with you. Take care.
Thank you.
Bye now.